Good afternoon, everyone. Thank you for joining us for today's National Service Criminal History Check session. We're going to cover the basic requirements and some of the different resources that you have at your disposal in order to fulfill this requirement. I'd like to first point out that we will be taking questions and answers throughout the session while I'm speaking, and we're going to have a moderator, Tawana Wright, who is a state program specialist from Alabama, who's going to be helping us with that. And at the very end of the presentation, we're going to read aloud your questions and give you a response as well. So keep those questions coming in as I'm presenting. So the first thing I want to talk about is what you should be thinking about as you are determining this requirement for your program. And I think a lot of the times people instantly gravitate to the word vulnerable populations, but actually the first thing they should be thinking about is their budget. So anyone receiving a salary or a stipend through a national service program is a covered position who will have to do these checks. So that could be paid from the federal share of the budget, or it could be paid from the matching dollars on a budget, or it could be a mixture of the two. We also have these new special grants. They're called senior demonstration programs, which receive no federal dollars but actually operate under CNCF authority. They also have to conduct checks on their staff and participants. The excess column in a senior corps budget, however, is not considered in determining covered positions for these requirements. And if you're a fixed amount grant, you would look at the individuals performing the activities as you've described in the grant application. So that's the first step in determining this requirement for your staff and your foster grandparents and your senior companions, and then we move on to the next step. There are 4 categories under which individuals are ineligible to serve or work. The first is if they refuse to undergo the check. Then, if anyone makes a false statement in connection to a program's inquiry about their check, they would be ineligible. I usually tell programs be very specific about how you're asking about someone's criminal history. If you ask someone something generic, like, do you have a record? They may say no, but in fact, in that state, something as simple as a speeding ticket could become a part of their record. So they may have unintentionally given false statements. So you don't want to set up the candidate for such situations. You want to be really specific about your inquiry. You may want to limit it to just the offenses and the convictions that you care about. So that leads me to the 2 offenses that CNCF bars people from service. One is anyone listed or required to be listed on a sex offender registry. They would be ineligible to serve. This has been a requirement as of November 23, 2007. So from the very beginning, this was an offense that would deem you ineligible to serve. Then in 2009, we added in anyone convicted of murder would be ineligible to serve. Now, although we added that in 2009, even if you had joined beforehand and say you had this conviction, you would have to be removed from the grant. That brings me to the first of 3 components that we're going to talk about today. This one is supposed to be the simplest check that you can do. It is called the National Sex Offender Public Website Check. It applies to all individuals in a covered position. So now I've already talked about the budget. So if someone is on that budget, they have to go through this check, whether they are staff on the program budget or whether they are the volunteers. This check is to be conducted nationwide. It is free. It is name-based, and it is public information, so it's online. This check the timing is very critical. It must be completed before the start of hours. So that includes training hours and orientation hours. You're required to do this check until all the state registries are cleared. So what happens sometimes is when you're conducting the check, you'll get a result. The result will say, today the California registry is not operating. If it says that, then you do not yet have a complete check. What you want to do is either recheck the same website until California is back up, or you can go directly to the California State Registry and print the result on that name from that registry and combine it with the original check that you did on this website to get a complete check. Now, if you have no hits from this check, you print out or you screenshot that there are no records found on that individual. That is your result. You maintain that result. And in that result should be the date that you conducted the check. Now, if there are hits, let's say there's a common name like John Smith, and there are 300 hits across the country with that name. What you would do is you would save the list of 300. Whether you print it out or you screenshot it, doesn't matter to CNCS. Either is acceptable. You would then look through each hit to confirm that it is not the candidate that you are selecting. You would confirm that against name, age, state, lots of different factors that are available on that result. And once you've adjudicated all and resolved all of the hits, you document that the hits are not the same individual as the candidate that you are selecting, and then the NSOPW check is completed. And you document it, and then you can start the person for service. That brings me to the second component of the criminal history check requirement. So this check is called a state repository check. CNCS requires you to go to designated state repositories. We keep a list of those repositories on our National Service Resource page, which I'll point to you at the very end of the presentation as well. You must check both the state of residence and the state of service. Sometimes in our programs, it is the same state. You are recruiting within your state, so you would only check one state repository. Now, state of residence is determined at the point of application. So when is the person going to apply to your program? Where were they living at that time? You can ask them that on an application. You can ask them that during an interview. However you choose to document that, that's the state of residence that you must check for their criminal history. The timing of these checks is also critical and very specific. These checks must be initiated no later than the first day. Now, you can do it earlier. You cannot initiate it later than the first day. Now, what does initiation mean? Initiation is one step further than getting permission to conduct the check. So, for example, that can be the date that you fingerprinted candidates. It could be the date that you mailed off applications to the state repository for the check. If you can save the mail receipts, it has to be something tangible and documentable to show that you have taken steps to conduct this check on an individual beyond just asking them, can we conduct a check on you? So we've talked about two components. Let's talk about the third one. The third component is the FBI fingerprint check. Programs must get their fingerprint check through the designated state repository. This is part of our final rule requirement. Now, that does not mean that all programs will be able to do this. I will discuss that further. The timing of this check is the same as the state checks. It must be initiated no later than the first day. Any hours prior to initiation are going to be ineligible. So you have to initiate both state checks and FBI checks at the same timeline. So no later than the first day. And I already talked about how you document initiation, something tangible beyond getting permission. And I want to talk about hours. So training hours, orientation hours, all of these are hours you're going to count towards that person's work or service. Therefore, initiation must be done no later than the first day. So I talked a little bit about how not all programs will be able to get the FBI check through their state repository. This is because state laws differ across the 50 states. And some state laws do not yet recognize this process or provide access to the FBI checks through their repositories. So what are your options? One option is that programs opt to do the departmental orders method. You're going to hear this term, and sometimes people just call it the DO method. There are two types of DO methods. One is to get ink cards to fingerprint an individual and submit an application requesting the individual's FBI rap sheet. The application to do it this way is available on the FBI website. This returns results in about 12 weeks. The second option is to hire an FBI-approved channeler. A channeler is a private business. It's a type of vendor that provides electronic fingerprinting for the application to the FBI check. This process returns results in about 24 to 48 hours. So when programs cannot get the check through the state repository, they often opt to do the departmental orders method. If you're going to do the departmental orders method, you're going to need special permission from CNCS to do that, because it is different than what is required in the final rule. The approval is pretty simple. It is straightforward. It's not very complicated, and we have 100% approval of all people who ask to use the DO method. So now I have explained the three components of the National Service Criminal History Check. But I want to talk about the two types of covered positions. The first type of covered position is the type of position that will have no access or will have episodic access to vulnerable populations. Episodic access is access that is not regular, it's not scheduled, and it's not an anticipated part of someone's job description. Recurring access, however, is now the ability on more than one occasion to approach, observe, communicate with an individual, whether it's physical, whether it's electronic, or through the phone. If you have recurring access, then you are in the second type of position. Now, in case we aren't clear on what vulnerable populations is by CNCS's definition, it is children aged 17 and under, individuals aged 60 and over, and individuals with disabilities. The whole purpose of this requirement is to screen individuals who are going to work under our grants and protect the vulnerable populations that our programs are serving. So now we're just creating a distinction of the type of covered positions. We'll see why that's important next. So in the final rule, if you had access that was not reoccurring, or if it was episodic, then you would just do the NSLPW check, which is the first check that we covered, and then you can choose to either do state checks or the FBI check. Now, what kinds of positions fall under episodic access or no access? Usually it's staff positions, positions maybe in the office that are working on finance, positions that are working on programs but are not going out into the field. They're not actually interacting with beneficiaries, but they're on the budget to manage this program. These folks would just do Component 1 and Component 2. Now, if you had access that's reoccurring, then you would do Component 1, 2, and 3. You no longer have a choice. Now, we talked about how long it takes to get an FBI check. It could take 12 weeks if you're doing the DO method through the ink cards. It could take the same amount of time if your state repository has is a paper process. So for 12 weeks, does the candidate just sit there and not do anything? No. Once you have the NSOPW cleared and you have initiated your state and your FBI checks, you can start service for that individual. You can start training hours. You can start orientation. If during that time, while check results are pending, you are going to give them access to vulnerable populations, they have to be accompanied. Accompaniment is very specific. It has to be performed while these checks are pending, and it has to be someone who is already cleared to have access to those vulnerable populations. It also has to be physical presence. So accompaniment is not the same as supervision. A lot of times people use that interchangeably. It is not interchangeable. Supervision can be done remotely. It could be a check-in that you have once a week. Accompaniment means you are physically in the same room while that individual is having access to the vulnerable populations. Now, who can do accompaniment? If you are on the grant, then you have to be cleared for access by CNCS's standards at the time that you joined the grant. If you are not on the grant, so for example, if you're working in the healthcare field and a doctor or a nurse is willing to do accompaniment while checks are pending, you wouldn't hold the doctor or nurse to our grant requirements because they're not on our grant, and you can use them for accompaniment because they are cleared by the nature of their profession to have access to vulnerable populations. Either way, if you're going to do this process, you have to document accompaniment because it's a requirement. You have to prove that you did it, which means you have to document it. So what's important to document is when accompaniment happened. When did accompaniment cease? So there is actually a point in time when you can cease accompaniment. That is if one of the two components clears. So component 2 or component 3. If the state checks come back and they clear the person for service, there's no hits of murder or sex offenses or anything additional that your program deems appropriate, then you can cease accompaniment while that third component is pending. So say that in your state, the process for state checks is very fast, and you get the result within 1 or 2 days. You can easily start the person and you can cease accompaniment in 1 or 2 days while you're waiting for, say, the 12-week departmental order process. That way you don't have to lose a candidate or lose them because they're waiting to serve. They came to do something for national service and now they're just in a waiting period. You're going to lose people that way. So accompaniment is there to help you start people while one of these two components are pending. I do want to talk about the past. So senior core programs are one of our oldest and longest running programs. So we have staff on the programs. We have volunteers in our programs who have been around while this rule has been evolving. So we hold those individuals to the time that they started on our grants. So that means we can't just forget about the past rules. We need to know them in order to make sure that the files that we keep on these individuals are appropriate and correct by the standards of that time. So I'm just going to go through it really briefly. November 2007, when this rule first came out, it only applied to individuals. staff and volunteers in the foster grandparent program, senior companion program, who had recurring access to vulnerable populations. At this time, RSVP was not part of the rule. The only requirements were to conduct the NSOPW and your choice of state checks or FBI checks. That was 2007. In 2009, the rule was expanded. The definition of covered individual became anyone receiving a salary or a stipend, including RSVP staff who started on or after October 2009. So this is really important to note, and it did not matter anymore if you had access to vulnerable populations or not. Now we were looking at the budget. Still at this time, we were only conducting two components, the NSOPW and your choice of state checks or FBI checks. And I want to emphasize the or. It's state or FBI all the way up to this point. It was in April 21st, 2011 that the rule changed. That's when the or became an and if you had recurring access to vulnerable populations. So speaking of those past participants, we did have some reach back in the final rule. If you were grandfathered in because the rule did not apply to your position and you never had a state check or FBI check, you had to self-certify that you had never had a murder conviction. Then you had to keep the certification in the individual's file. Now, this is only if they had never undergone a state check or an FBI check. If they have gone through those and cleared those in that time, then you wouldn't have to do the self-certification. That doesn't mean all individuals in our programs have to self-certify. Not at all. This is only for folks who got grandfathered in based on the rules in 2007 and 2009. They would have to self-certify. Now, if you joined the program before 2009, remember, we added murder as an ineligibility conviction in 2009. So if you gave a result to us in 2008, we wouldn't have looked for murder. So what we wanted programs to do is go back, look at the state and FBI checks that were conducted on those individuals, and confirm that no one had a murder conviction. And if anyone did have a murder conviction, they would have to be removed from the grant. Also, if there was a chance that you were grandfathered in for conducting the NSOPW, you would have to conduct a National Sex Offender Public Website check as of January 1st, 2013. So an example of this would be like RSVP staff that became part of the rule in 2009. It was only new staff. So if you were RSVP staff from pre-2009, you were grandfathered in. However, on January 1st, 2013, you had to add into your file this NSOPW check. So this is some of the reach back that came out of the final rule. So I just want to highlight this because I know that we do have staff and we do have participants from a couple years back. Two additional rules that I want to update you on is that we increased the break-in service from 30 days to 120 days. For Senior Corps, break-in service means termination or inactive status, and it really depends on how you define that in your policies and procedures in your program. So if there's a Senior Corps foster grandparent and they go into inactive status and they come back within 120 days, you do not have to recheck everything. You keep the checks they already passed, and if you have to supplement, then you do that. So that brings me to supplementing checks. So if anyone changes positions after January 1st, 2013, and has recurring access to vulnerable populations in that new position or new assignment, you would supplement anything that's missing. this even applies if you have less than 120-day break-in service. So a foster grandparent who used to be on the grant in 2009 was only required to do two components. They would do the NSOPW, and say you opted for the state check for them because it's a single state and your state repository process is relatively simple. Well, they went and had a break-in service. It was 100 days. They came back. They wanted to rejoin. Now you would have to add in the FBI check because they will be having access to vulnerable populations. So any change after January 1st, 2013 in a position, whether you're a staff position or you are a returning foster grandparent or student companion, you would have to supplement checks for your position. So for example, another thing to think about is a staff position that promotes or goes parallel or has a change in title. So if you were a coordinator and you become the director, it's a change in position. If that happened after January 1st, 2013, you would again supplement checks based on the type of access that position had. So if you had no recurring access as a coordinator and you began to have access as a director, then you would add in whatever components were missing for your criminal history check. That brings me to vendors. For the longest time, many programs have been engaging vendors on doing checks. Now, these vendors are different from the vendors I mentioned that do the departmental orders method. Those vendors are FBI-approved channelers. If you go to the FBI website, you'll see a list of approved channelers that you can use to do the electronic fingerprinting to get the checks. That's different from what I'm talking about here, and I'll explain how. So in the past, programs have been using vendors, and vendors have been mirroring CNCS language about checks. So a vendor will tell you, we have the best state checks in the nation. We have the best national check. Now you're thinking, okay, CNCS requires me to have a state check. Sounds like this vendor is doing a state check. $9.99 sounds great. I'm going to do it. Case solved, no problem. National, okay, that sounds like, the FBI is national. That sounds like what I need. I'm going to do it. The problem with that is it's not a match. Their state check is not the state check that we're asking you to get. Their national check is not an FBI fingerprint check. That is the first thing you'll realize, that if they're not fingerprinting your candidates, then they're not even giving you close to what we're asking for. So what you want to do is assess your vendors very carefully. You want to ask them to explain to you what their data sources are for getting these checks and how those data sources line up with CNCS's required data sources. If they do not line up, you cannot use that vendor for that component. There are vendors that are doing some of these components well. So they might be doing the NSOPW well. They might be doing 30 out of 50 states well. They might even now be providing FBI checks. But is there a vendor that's deemed, compliant by CNCS? No. There's no vendor that does all 50 states correctly or matches them to our sources, just so everybody is clear on that. So you can use a vendor, but you can only use them where they match our sources. So you would be very fortunate if you only needed a few states. Say you recruited from one section of the United States, say the South. So the vendor gets all of their checks from the correct state repositories there. You're okay. You don't have to come to us for any special approval. They match us on data sources. That's perfect. But that's what you need to ask them, and that's what you need to be sure of before you spend the money to get a check that may not even satisfy our requirements. Remember, these are businesses. They're selling you something. Another very common issue with vendors is that they limit data to 7 years. So vendors are businesses, and they have to be compliant with the Fair Credit Reporting Act, which limits data sharing to 7 years. CNCS requires that you get data as far back as the repository holds data. So if someone has been convicted of murder 15 years ago, served their time, and now wants to volunteer with your program, you would not see that in the 7-year limited data information. So that's why that is not enough to make a compliant check for what CNCS is asking you for. So you want to ask your vendor, can you go far back as the repository holds data? Most vendors can do that because you have a legitimate business purpose for asking for that data. The next thing is results. A lot of our programs left it up to the vendor to maintain the results. They did not have an agreement in place with the vendor to maintain the results as long as our grant requires you to maintain documentation. You know, there are documentation requirements that come with CNCS grants, and a vendor might only retain data for you for a year or until you have a contract with them. So you want to make sure that either you take responsibility for those results and you get those results from the vendor, or if you are going to let the vendor maintain them, which is perfectly fine, you have an agreement in place that that data is maintained as long as your grant needs for it to be maintained. Vendors will sell you products, Social Security searches, credit reports, motor vehicle reports. These are all possibly relevant for you. However, they do not speak to sex offenses or murder convictions for the baseline requirement of CNCS. So if you wanted to get these other packages, that's perfectly fine. Just know that when a vendor is selling you these, they are addition and not anything to do with what CNCS is asking you for. That brings me to alternate search procedures. I first mentioned this at the beginning of the presentation when I said if you're going to opt to use a departmental orders method, you're going to need special approval from CNCS. This is that special approval, the alternate search procedure. So if you're going to request an alternate search procedure, you would fill out a form that we keep on the National Resource page, and you would check out the boxes for what you're asking for and provide a brief description of why you would like to opt for that procedure. And while your decision is pending, and if you have access to more populations for that individual, you would perform accompaniment. So basically the ASP process is there for programs who will be varying from our requirements in any shape or form, and they want their process to be considered in lieu of our process, either because they think it's substantially equivalent or better, or that maybe there is a state law that is prohibiting them from following the federal law. In that case, you would share the statute or the prohibition with a legal analysis, or maybe you get a rejection letter from the state repository saying we can't give you checks and we cannot give you access to FBI checks. Whatever that is, this is your way to communicate with CNCS when you run across a problem. So when you come to doing and fulfilling this requirement, it will not always be 100% smooth sailing. There may be points when the repository doesn't recognize the type of service you do, doesn't recognize, maybe the state statute doesn't recognize certain categories of programs. When you run across that, you need to communicate that to CNCS so that we can work with you to get you compliant. This is not a time when you hit a roadblock and then you stop attempting to do the checks. So this is your communication method. There's a specific email address to which these requests go, and you submit the form. You copy your program and grants officers. You want the program officers and grants officers to know the challenges you're having. You want them to be your advocates in getting you through this process. And they need to be aware that you are making attempts and doing due diligence in fulfilling this requirement. That brings me to the FBI exemptions. There are 3 categories under which programs can apply for an exemption. Sometimes program calls this waivers. We don't like to call them that. They are exemptions. They are in the regulations. These 3 categories are where you can make a case for why your program cannot or should not have to do the FBI check. So either you have a good cause for that, or it is cost prohibitive to your program. So you have to make a strong case about how the fees increased from 2 components to a 3-component check. Remember, a 2-component check has been in place since 2007. So it's only 2011 or even 2013 in which the 3-component check became required. And lastly, if you're prohibited by law. So this is the one we get that's most common and easy to approve when a state repository rejects you from conducting a check and gives you a denial letter, whether it's email or it's a paper letter. You can submit that denial to CNCS and get a 1-year exemption. All exemptions are only 1 year long. You have to reapply when they expire because laws change and requirements change and so forth, and state processes are also fluid and changing. I'm going to quickly go through the documentation. You're going to want to save documentation that you verified identity, that you got written consent from the candidates, that you got the documented understanding that the candidate understands that his position is contingent on the results. If you're going to a vendor, you need to document the sources the vendor is using. You want to document initiation, accompaniment, the receipt date for when checks cleared, that you considered the results of the checks, and you want to maintain the results of the checks. So you don't want to shred the NSOPW. You don't want to lose the state check. You don't want to lose the FBI check. These are very important because they are proof that you actually conducted these checks on the individual. That brings me to discussions and questions, so I'm going to pass it to Tawana to please read aloud some of the questions we've received so far so that I can respond.
Thank you, Kenza. We have recurring questions here. They want to hear information about the veracity of the murder conviction. If someone is a murderer, do we look rather foolish taking their word about it? How do we determine whether the self-certifications are enough?
That's a good question. So basically, in terms of the limited amount of individuals who have been in our programs for years and never went through a state check or an FBI check that would have to self-certify, you have the option of doing more than the self-certification. Self-certification is the minimum that we're asking you to do because our rule changed. If you want to use grant funds to go over and beyond and do a state check on them or an FBI check on them, you can do that.
Next question. For volunteers who have served for more than 5 years, should we repeat the criminal background checks?
So from CNCS's point of view, these checks are done when you first join a national service program. So when you first join, you are new. We have no relationship with you. We don't know where you're coming from, what you've done in the past. One we've run the checks on you, we have a baseline, and that relationship continues. If the program wants to create additional requirements to run these checks more frequently, that is perfectly acceptable, but it is not a CNCS requirement. Sometimes you are placed in schools or you're placed at healthcare facilities. They require you to do them every 2 years, or they have their own requirements, and that kind of covers that as well. So it's really up to the program to make that determination.
Okay. When fingerprints are determined to be unreadable by the state repository, how do we handle that?
This is a really common question that we get. Basically, the state repository should have a process for rejected prints. It tends to be 2 to 3 rejected attempts that result in you getting the name-based FBI result. If a state repository does not have a process, or you are functioning outside of a state repository, then you need to come in and communicate that to CNCS through the alternate search procedure.
Because the FBI check also includes a check of the sexual registry, why are we required to do both?
You're required to do both because of the timing. NSOPW is instant, it's free, and it's online. So that clears an individual on one of our major conviction, barring them from service instantly. FBI checks, like I said, can take up to 12 weeks. So not knowing that for 12 weeks means you cannot start that person. And so it's really about the timing, about why we require both. Some programs do have an FBI check cleared before anyone even starts, and that's great, but the law requires us to do all 3 components, and it came up with that because of the different levels of information and the timing of that information combined, creating a much stronger screening process.
Our next question. If a volunteer received a notice of denial from the FBI, what process could they go through?
So the FBI allows individuals to request their own record. So the individual can request their rap sheet from the FBI and see what their record shows. Then they would have to go to the appropriate recording court to dispute anything that was incorrect.
Could you please explain the check requirements for the RSVP programs once again, please?
Sure. So for RSVP, the requirement came into play in 2009 for new hires, and this only applies to staff. So RSVP volunteers are not covered under CNCS. Now, I've said that, but you will find a lot of sponsors or volunteer stations have their own requirement because RSVP volunteers do have access to vulnerable populations. So in that case, you have the option of adding RSVP volunteers to your budget for criminal history checks because it is an allowable expense. But it is not one that we would monitor or do oversight on.
If a volunteer is forced to be away for more than 120 days because of medical reasons, is there a difference in that break-in service?
Yes, there is a difference, but it really also depends on how that difference relates to your policies and procedures. If you choose to move that individual because they're on medical leave into inactive status or terminate them, then yes, that 120-day break-in service is a true break-in service. If, however, for you medical leave is not a break-in service, that is acceptable. For example, sometimes programs or individuals take summers off, and that could be 3 or 4 months off. Taking leave that is part of your agreement with the program, leave is not the same as them moving you into inactive or terminated status. So it really depends on your policy and your determination of these sort of activities. So like if a staff person takes leave, say they've accrued significant leave or they have medical leave, you wouldn't terminate that staff person. They would still be your employee, but they would be in a different status. So it depends what that status means to your program. If you would terminate someone based on that, then that would be a break in service. If they're just moved into an inactive status that you don't think is the same as terminated, you wouldn't have to re-staff them or re-enroll them through the whole process. Then it's not a true break in service. They're still serving. They're still active in your program. If that's not clear, you can ask me over email, and I can, give you some language in writing.
We have time for one last question. Okay. If a state law bans fingerprinting of volunteers, should the program request a DO?
The state law bans fingerprinting. I have not heard that one yet, but if you do find that a state repository will not conduct checks and you opt to do the DO, that's perfectly fine. You just apply for an ASP and you explain your situation. ASP is alternate search procedure, and you would be approved to do the DO. All right, well, that's all the time we have to do questions today. I just want to thank everyone for your participation. Any questions that are not answered, we're going to move them to the discussion forums for response to you. I want to just promote that tomorrow we also have a session on challenges in the criminal history checks at 11:30 Eastern Time. I encourage you to attend that. Thanks, everyone, so much, and thank you, Tawana, for being our moderator today.